Good evening, everyone. Sorry we are starting late. I believe we'll start the session now, then wait for more people to join in. So, we welcome everyone to today's session. Please permit me to just share my screen. Okay, please, can anyone hear me?
Yeah, I can hear you.
Okay, thank you. Well, can anyone see my screen?
Yes, we can see it.
Okay, thank you. So I welcome everyone to week one. Week 4 of the JIIPCC Mentorship and Internship program on the entertainment, business, and law session. So I also thank our mentors for joining in early. They were on the call before the mentees started joining in, so we appreciate them. So I'll go ahead to reading the mentor's profile. So first on the list is Mr. Raphael Efe Irenen. Mr. Raphael Efe Irenen is an entertainment, media, and intellectual property lawyer. He is the founder of TMT Africa, a platform that serves as a resource center and reference point for all for all matters concerning technology, entertainment, media, telecommunications, intellectual property, and fashion in Africa. He was formerly an associate in the Entertainment, Leisure, and Media Law Business Unit at Alaniwun Ajayi LP, a multi-international corporate and commercial law firm headquartered in Lagos, Nigeria. He was also an intellectual property and technology associate at ALEX Partners, where he was seconded as a legal associate to Pruneged Technologies Development Limited, an international technological services company also based in Lagos, Nigeria. He has advised a wide array of clients, including international and local clients, on intellectual property, technology, entertainment, and media matters. He is well versed in the realm of entertainment and media law. So welcome Mr. Raphael to the call today. So next on the list is Mr. Oluwaseyi Arowosebe. Mr. Shea is the principal partner at Dilex Consults, a corporate and intellectual property law firm based in Abuja, Nigeria, serving clients across the country and globally. The firm has advised hundreds of clients in the formation and maintenance of corporate entities and also safeguarding the intellectual property of individual and corporate entities. He is a facilitator at the Intellectual Property Institute Nigeria, where he teaches trademark and copyright. Shea holds a Master's of Laws degree in Intellectual Property Law and Policy. He's also an alumnus of the prestigious Lagos Business School. Thank you, Mr. Oluwaseyi, for joining in today. And next on the list is Professor Samuel Samai Andrews at AL Yamama University. His role encompasses educating the next generation in the practice and profession of law, including intellectual property law, with a focus on its intersection with Sharia, as well as engaging in research and curriculum development. His responsibilities reflect a continued commitment to merging innovative legal education with traditional principles. As an off-counsel as the Law Temple Associate, he provides expert legal advisory services, leveraging deep knowledge in IP, rights, management, and commercial law. The organization benefits from his multidisciplinary approach to law, particularly as he navigates the complexities of intellectual property rights and artificial intelligence systems, evolution in ownership and management spaces, which includes cyber criminology and criminal justice. His expertise in international corporate law and a keen interest in protecting creative rights within emerging economies. His contribution extends beyond academia to influence the global understanding and enforcement of intellectual property law. Through collaboration and research, he aims to empower the creative industries in the global south, including Nollywood and African films. So we thank Professor Samuel Andrews for joining in today. So moving forward, we'll be moving to our next agenda on the list, which is hearing from our mentors what the brief insights on the topic today that we'll be having. So we would love for Professor Sami Andrews to begin.
Okay, good evening, everybody in Nigeria and wherever you're listening to, watching. Okay, it's an interesting topic. We're talking about, I have a little thing to share here. Let me see. You cannot screen one or the other. Could you help me take off your sharing so that I can share something?
All right, so I'm coming.
Okay. It's my documents. Oops. Let me start that again. I'm still looking for my document. Yep. Strange. Okay, there's some problem here. It's my document. Where is it? I don't want to share that proprietary things. Let me see. I don't know where this document is hiding. Document. Okay. Okay. Yep. It's a little bit of technological thing there. Okay. I'm sure you can see my little thing there. Okay. All right. So, like I said, I think I'll give myself 10 minutes if that's okay. So it's an interesting topic, really. We're talking about comedy skits in the digital era of creativity. But I have a little talk. I've gone through. Hope you are hearing me. If you can't hear me, let me know. Oh, I've gone through the PowerPoint. It's a very good thing the group has done, which I'm sure we're going to talk about those points. But I'm trying to, because I've done this work a while ago. I think this paper was published maybe 2020. But I realize it's still relevant, even though I'm working on an expansion of this theme which is coming out probably soon. But what I want to focus on, based on what I saw in your presentation, is we have to, although this paper that was published, I brought the whole context for everybody there. So it's put it in an image form so you can download, or you can go to my website and download it's free, it's open access, so you can easily download the entire PDF. But on this PowerPoint, I've tried to bring all these pages here. So the comedy, skits, and digital works. So what I have basically seen, or what I think mostly when we are talking of comedy skits, especially in the digital platforms, meaning in the internet, let's put it that way, or in our wearing devices. What comes to mind basically as an IP scholar and as an IP lawyer is you got from the practical aspect of it, what is the law? What are the regulatory framework that is the right one for if you're advising a client, or if you're a creator yourself, what are you thinking of before you put things out? Now, that's on one layer. On the foundational layer is, because here I use Nollywood. Nollywood is an omnibus term in the creative culture, especially Nigeria brought it up. It's very popular now. So if I talk about Nollywood in India, everybody understands it. If I talk about Nollywood here in America, that I am right now, everybody knows what we're talking about. So it's epitome of the audiovisual creative works. So the first thing I will be thinking about, what's the legal framework? What's the policy framework? So it takes me now to the core of where I am, that's IP. But what is the best IP first? Now you realize, if you understand a bit of copyright or IP, you realize that the foundational law is first on the pyramid, the jurisprudential pyramid. At the tip is going to be copyright. Why? Because the skit or comedy itself, in the comedy as on its own or on a digitalized environment or skit, we'll talk a little bit about the small differences between comedy and skit, which I don't think there's any difference really. It's an artistic work. On when it's done on a plain platform, when it's been displayed visually or by audio, you'll be thinking about the definition of subject matters that the law, which means copyright, protects. And it's falls squarely on being is an artistic work. Of course, before it becomes an artistic work, it has to be a literary work. Meaning, if you want copyright to protect it, you have to write it down. You have to write your jokes. Comedy is making people laugh in elementary or literary interpretation of what comedy is. Make people laugh. We see it all on YouTube. So you got to write it down. If you don't write it down, you have a problem, because now you may not really have too much of a basis to hold on to at the back end, downstream, if you want to claim damages. We're going to talk about that during the question and answer. So, as soon as you write something on a tangible platform, copyright attaches immediately, meaning you don't need any registration for copyright to protect your creation, especially your literary creation, your painting. So when you do that, then you have to practice it. You have to take it out to the public, display. That's where you come in and put it on YouTube. That's where you come in and put it on Instagram and all the other, distributive mediums that the digital era has enabled. So you realize that at the core of this is copyright. Then the next level, of course, maybe you are not yet a big creator in terms of deep pocket. You might be talking of patent, because you might decide to create a software or a system, a technology. You can develop a technology that will take your skit or your comedy into a bigger system. That's, we know, patent protects inventions, ideas that have been put into, a concrete form, as long as it qualifies within the eligibility metrics of what subject matters that patents ought to protect. So for me, then the next level you'll be looking at, probably you want to commercialize your craft. You need a name. You need a logo. For example, Alibaba. You need something like, a design to give people that brand. You want to give yourself brand now. So when you create this comedy or this skit, you want to put it out, you stamp your logo on it. So that's where trademark also comes in. So principally, they're going to be at the primary level. You have 3 basic IP laws that you can use to protect your creative act or your innovative ideas. But now the next level is now the issue of comedy and skit. So people say, what is skit? Can copyright really protect skits, or can IP law protect skits? Because I saw a definition somewhere saying skit is a short form of whatever makes you laugh. I think it's just a nomenclature used. It's comedy, basically. Well, the fact probably is a professional nomenclature used by, mostly the film industry. It's a shorter form of probably a formal comedic episode. So it's still protected by IP. It is not the duration of it that determines its protection. It is going to be the creative element, whether it's original, whether it's within what the law subject matter of copyright, or whether it is expressed, So once you get those basic foundational eligibility squared, this kid definitely is going to be protected. The same way, even if it shows for 5 seconds online and there is a trademark, a registered trademark on it, it's still going to be protected. So it's not about the modicum, it's about the creative element that aligns with the law. So like we know in Nigeria, Nollywood is a foundational step that gave us the current form of comedy in Nigeria. You know, it was, like I said, I wrote in this piece and somewhere else, it was from Nollywood per se, especially the first generation comedy, or Sophia Goes to London, and those early stage of Nollywood had some comedic elements. Now, the modern day comedians in Nigeria or skit makers now they've succeeded in doing what I call the stand alone. So yeah, the skit and the current form of comedy is a development that is very laudable, because now as an industry, we've seen that comedy is a standalone apart from the main Nollywood or the main new Nollywood. New Nollywood meaning the highly digitized or highly distributive methods of the audiovisual content in Nigeria, where they rely on the elements of the internet to distribute their work. So that's where we are in Nigeria. It's a very robust system or industry, and something great also has happened in the area of comedy and skits. We now see animation. I hope a lot of you are paying attention to that area that is emerging. Animation it's really rich. In fact, the projection is that animation is going to make more money. Currently, right now, animation is making more money than regular traditional films and all that. All the games you see, animation is a big thing. So I know that few players in Nigeria are into animation, and you'll see there's so many skit animations, comedic animations now floating in from Nigeria on YouTube and other channels, Netflix and the other online streaming platform. So I just want to encourage us to pay close attention to the legal framework, the best form of regime when you're advising your clients. And registration is still, for me, speaking for myself, and I'm as far back in 2014 when we were working on the current copyright law as part of those who were working on it and presenting, sending papers. I just felt that registration of works around copyright issues in Nigeria, it's still, from what I'm seeing, from the practical and legal aspect, is still troublesome, because I know we copied it from America, because America, if you really want to have standing, if you want to sue, if somebody infringes on your copyright, you should register that copyright. But America is so developed that, and again, for issues of statutory damages, meaning if you want to get that $50,000 statutory damage, yes, I think $50,000 statutory damages per infringement, and then is it 5,000? I've forgotten now, but I think it's about 50,000 or 5,000 per infringement. Then you should have registered that your copyright. But what I'm really interested in letting all of us know is that you shouldn't confuse registration of your work with the Nigerian Copyright Commission, because that's what the current law, the Copyright Act of 2022, if I'm correct, yeah, 2022. Don't confuse it with your copyrightability, whether the work that has been registered actually is protected by copyright. It's a little bit nuanced, but you have to realize that you don't need, copyright does not avail you when you register your work. Copyright avails you as soon as you create the work. So you don't need to register your work with anybody before you have the protection of IP laws, especially copyright. I'm sure I'm going to get questions from that. But somebody will now ask, then why do we have to register with the Nigerian Copyright Commission? Well, that's the law in Nigeria, so you have to follow the law. But I can tell you the policy, the policy thinking about why the Nigerian Copyright Commission wants you to register. It's purely administrative issues to basically have a directory so that I think they can manage rights, disputes, and all that in their areas of alternative dispute resolution. But registering itself does not confer you. So don't make the mistake that because you've registered, you run to Copyright Affairs Commission, because I see a lot of that in Nigeria, for them to adjudicate your case because you registered with them. They don't have that right to say that. It's only the courts that can determine whether that work you registered belongs to you, whether you own the copyright. Because people can register people's other work. So I did it, my name is there, but it is the forte of the court to now decide who owns the copyright. You know, stories of Olutore and all these disputes that have been going on. There's, I think, one going on now about contract, about a movie. The last one we just saw, a lady producer who had her movie put down on YouTube until they clarify. Somebody used the Digital Management Copyright Act of America to petition YouTube to put down the movie because they claim that the lady infringed their copyright. So those are the kind of issues we should pay attention to in the digital environment. And I hope you would read more, take time and read this paper. It's a short paper, about 6 or 7 pages, you know. So thank you. I'm here. I think I will stay along and listen to you all. I appreciate it. Thank you.
Okay. Thank you very much, sir, for your presentation. One or two from it. So really appreciate you, sir, for coming in today. Secondly, we moving to Mr. Raphael.
Yeah.
Mr. Raphael, thank
Yeah. Good evening, everyone.
Good evening, sir.
Yeah. So my understanding is that the topic for today borders on comedy skits and digital content. So I understand that ultimately we have to streamline whatever we are teaching today to intellectual property. But then I would like to permit me to start from attending to this topic from a general standpoint, rather than just streamlining it to intellectual property. So comedy skits and digital content are like they are primarily a product of recent innovation, uh, particularly as it relates to social media, as it relates to the use of the internet, and all of that. So when you talk about comedy skits and digital content, there are a couple of legal concerns, not just limited to intellectual property. Intellectual property is there. Data protection concerns are there. Cybercrime concerns are there. Cybercrimes concerns are there. We also have even down to litigation, like disputes in general. At the end of the day, where there's a breach of intellectual property rights, where there's a breach of, where there's a cybercrime issue, where there is defamation and all of that. I was about to mention the law of torts, like tortious claims are also there too, like defamation and all. So I'll start with data protection. You know for a fact that data protection laws seek to primarily regulate the use of personal data. Comedy skits and digital content. When you put out your skits, when you put out digital content, you are required by law to ensure that whatever content or skits that you're putting out do not breach the personal data rights of others. So, because if you do, you'll be liable for data breach that is strictly data and privacy breach that are strictly prohibited under the Constitution of the Federal Republic of Nigeria and the Nigerian Data Protection Act. And that's the new Data Protection Act. It even extends down to the Nigerian Data Protection Regulation. That was the primary data protection law enforced before the act was enacted. You have to ensure that whatever information you're putting out there, if you're putting out the information of someone, you need to get the person's permission before you put out such information. Then down to cyber crimes concerns. You know, Nigeria, for example, as we currently have the Cyber Crimes Prohibition and Prevention (ETC) Act of 2015 that regulates matters concerning that regulates cyber-related matters, like matters that are related to the internet, that are related to social media and all. You have to ensure that whatever content you are doing does not breach the provisions of the Cybercrime Act. So how is it possible to breach the Cyber Crimes Act? For example, the Cyber Crimes Act prohibits child pornography. So you have to ensure that whatever content you are doing does not include any pornographic content such that it relates to a child. The Cyber Crimes Act also prevents cyber squatting. So the provisions that prevent cyber squatting can be interpreted to the extent that it also prevents intellectual property theft. So there is an extent to which you will be in breach of someone's intellectual property, such that you become liable under the Cyber Crimes Act. You know, when you talk about comedy skits, when you talk about digital content, most comedians, online content creators, they also double as influencers. So they advertise for brands and all. There's a bit of an advertising concern there. I know the Advertising Regulatory Council of Nigeria, the ARCON, and the laws and regulations that establishes the ARCON also regulates advertising activities too. So coming from an advertising standpoint, you have to make sure that whatever advertisement you are putting out is such that it does not it falls within the scope of advertisements that are permitted by the ARCON, particularly the standards panel. The ARCON has a panel called the standards panel that regulates all advertisements before they go out. So if a brand is asking you to do an advertisement on their behalf, you need to ensure that that advertisement meets the requirements that is stipulated by the standards panel, the ARCON standards panel. Then, in terms of intellectual property, as we all know it, there are different types of intellectual property. We have copyrights, we have patent and design, we have trade secrets, we have trademarks, and there's one last one that is not particularly popular in our client. Just as trade secrets isn't regulated, it always escapes my mind. But I haven't really done much on it because it's not popular here in Nigeria. So if I remember it, I'll send information pertaining to it to the JIIPCC Academy to share with the students. When you talk about comedy skits and digital content, there are various concerns. So let's start with trademarks, for example. I just mentioned that can anyone confirm that you can hear me? That you can hear me? That you guys can hear me, rather?
Yes, sir. We can.
Okay, so when you talk about intellectual property concerns for digital content and comedy skits, we'll start with trademark. So it's possible for you to be a content creator or a comedian, and the name or the moniker under which you perform is a name or moniker that already belongs to another person. So most people do not actually know that before the current basket mouth, Bright Okocha, there was a basket mouth before. I don't know if he died or I don't know what happened to him. So you need to ensure that whatever name you are performing with, whatever name that you're putting your content out with, is your name, is a product of your is a product of your exclusive thinking, such that no other person uses that name. That's one. If not, you'll be in breach of the other person's trademark if it is registered. Now, even if it is not registered, even if the other person did not register the said name, you can also be in breach to the extent of passing off. So if the person is able to establish the necessary ingredients for passing off, you'll be liable under law. Then, talking about advertising for brands, it's also possible for you to put out an advertisement on behalf of brands, and automatically you become an accessory to trademark infringement because the brand you're advertising has a name similar to another name. So we have a recent case now, this Zap app that was built by Paystack, the Paystack guys. So another set of persons came out to say that, they were already using Zap. I think their own name is Zap Africa. So it's a trademark concern. Now imagine Paystack already paid some influencers to do some influencing job. Obviously, they themselves would automatically become a party to a trademark infringement claim. So you have to observe that. Then moving forward, in terms of copyright, like the prof already said, by virtue of Section 2 of the Nigerian Copyright Act of 2022, that's our recent Copyright Act, our extant Copyright Act, comedy skits are protected under audiovisual work. Now, it's not very clear. Under this new dispensation, it's very clear that if you put out a comedy skit or if you put out an online digital content, which more often than not is a video, videos rather, online content are in visual forms rather, they are protected under audiovisual works as provided under this new Copyright Act. In the previous one, what we had was cinematograph film. We didn't have an audiovisual work as a work that is eligible for copyright. The implication of this is it was very dicey then to determine if online content, the defunct Copyright Act was made and enacted in 2004. It didn't take into cognizance technological advancements of today. You understand? So it's because of the current technological advancements, the current rise in innovation. I think it's one of the reasons that prompted the Buhari administration to enact the Copyright Act, the current one that we have today. So in this dispensation, audiovisual works are protected, including comedy skits. Whatever content you put online is now protected. So you need to ensure that your content is not such that it copies the content of another person. You need to ensure that whatever you are using for your content, whatever materials you're using, so some content make use of music. They make use of either sound recordings or musical works. You need to ensure that the sound recordings or musical works that you're using, they are either your original works or if they are works of other persons, you obtain their permission, the permission of those authors. We saw was it this guy Brain Jotter that made use of is it Gwagwangwa? I've forgotten exactly what they called that guy, that song rather. He made use of that song, and there were so many. I think a lot of IP lawyers came up to. There was this trending debate online as to whether he was liable for copyright infringement for using the work without the man's permission. So many persons claim that it was fair dealing or fair use, and as such, he's not liable. Other persons claim that he was liable and all. So at the end of the day, whatever song you are syncing with your videos, even your audios, podcasts are online content too. They are digital content too. So if you are using a song in your podcast, for example, you need to ensure that the song you are using is cleared. You obtain the permission of the musician, of the singer. Then I think for patent and design, the issue of patents would come into play. Like Prof said, if you are building a software or an application through which you intend to push out your content. When Prof said it, I know a couple of persons must have felt it's a reach. I mean, it's not something that we see every day in Nigeria. How many comedians or content creators have the leverage or the time to create an app to put out their content? Well, I am yet to tell you that it's not a reach. It's already obtainable here in Nigeria. We're seeing it here in Nigeria. So there's this love show, this romance show that is organized by a popular Nigerian content creator. I've forgotten her name now. Yeah, guys, they pop the they pop balloons and all. So I was going through. So whenever I go to work, I pass the Lekki Ekpe Expressway. If you pass there, close to, is it Law School or Quillox, you would see a big signpost. Okay, close to Azon Mobile, you see a big signpost that is advertising an app, an application through which you can be involved in the love game. So if we're already seeing that, it means that people can obviously create softwares or applications through which they'll push out their content. And in my opinion, which is premised on the law, it is patentable, very, very patentable. So that is where patents can come in. Then in terms of trade secrets, unfortunately, we do not have extant laws that regulate trade secrets in Nigeria. Even the TRIPS agreement, where Nigeria is not a signatory to it. A couple of developed countries are, but Nigeria is not. Okay, pardon me. I think Nigeria is a signatory to it, but it has not been domesticated as required by, I think, Section 8 or 10 of the Constitution. So what that means is that it is not an extant law in Nigeria. It is not obtainable in Nigeria. However, trade secrets are the laws governing trade secrets. The laws governing trade secrets are imperative because comedians, content creators, they come up with concepts which they discuss with people. They discuss with their colleagues to put out. Now, before you put out that concept, before you share that concept with a colleague who is obviously a rival, you understand, because it's possible for Basket Mouth and Bovey to crack the same jokes. It's possible for Brain Jotter and Mr. Sabinus, to put out the same content. So before you put out the content, or before you share share the idea of the content with your colleague, you can get them to sign an NDA. As it stands now, the only protective measure for trade secrets we have in Nigeria is the NDA system, the non-disclosure agreement system, whereby we can get parties involved in the dissemination of the trade secrets to sign an NDA. You understand? So you can get your partner, your fellow content creator that you are sharing an idea with, to sign an NDA to protect the trade secret. So I do believe that these are the legal concerns or the areas of the law through which digital content and comedy skits can be protected and all. So By way of a recap, we talked about advertising, laws governing advertising, we talked about data protection, we talked about cyber crimes, we talked about intellectual property, and I also made mention of the tort on tortious claims, like the law of torts too. So you also have to ensure that whatever content you are putting out is not such that they are defamatory or they are likely to breach public peace. Okay, for the breach of public peace, we can refer to the Constitution, we can also refer to the Cyber Crimes Act. But primarily, whatever content you're putting out, ensure that they do not defame others. If you are putting out a content under the guise of constructive criticism, ensure that it is actually a constructive criticism that is allowed or permitted by law. Do not put out content that defame others, that outrightly slander the personality of others, and expect not to be not to be caught by the law and tried or sued or prosecuted, as the case may be. So, yeah, thank you very much for your time. For the sake of time, I think it's imperative that I stop here. Thank you.
All right. Thank you very much, sir, for the insightful discussion. Really appreciate it. I hope the mentees have been able to get few things from what you've said. We'll be moving on to the next mentor for today, which is Mr. Oluwaseyi Arosebe. So, sir, please go on.
All right. Thank you so much for having me. Good evening, Gypsy. Good evening, mentees. I greet you, Prof. Andrews and Mr. Raphael. Thank you for insights you shared ahead. By way of introduction, Prof has done extensive work, introducing us to the basics of what we are going to be doing tonight, and also Raphael building on it. So I'll try to limit my intervention to a few of the things they've not mentioned. They've almost covered gap, but in my own introductory notes, I talked about how digital content has transformed the way individuals and businesses communicate, entertain, and educate their audiences. On our seats, wherever we are, we can begin to mention content creators, online artists who do things to entertain us, to educate us. We have the apropos doctors of this world. We have the Macaroni. We have the Brain Jotter. We have MC Lively. Many of them churning out content day in, day out, ensuring that we stay glued to our screens. Now, there are many legal principles that follow some of the things they do. Some of them have been shared already, and I'll be chipping in one or two of things that have not been said. Okay, so Prof has told us there's automatic protection for copyrights, for copyright works, although the new Copyright Act now says we should still register. Yes, for business reasons, I feel, fund generation for government, and importantly, when it is time to enforce your right in copyright, it will make more sense when you can show a certificate of registration, so that you notify the Copyright Commission of your work, and it will give you some credit. Just like if you register your trademarks, you have a better chance as far as in addition to someone else who didn't register, who can come under personal. Okay, so I'll be speaking on the doctrine of fair use as it relates to copyright. Fair use offers some flexibility by allowing limited use of copyrighted materials without permission, often for purposes of criticism, commentary, education, research, and parody. Now, the court, in determining what amount of fair use, will look at 4 factors. And one of them is the purpose of your use. So if you are using the work of another person for commercial purposes, then you cannot be said to come under fair use anymore. You cannot be making economic benefit from the work of another person in the name of fair use. That means you have crossed a line. Now, factual works may have more leniency than pure creative work, and also smaller portions are safer. So the less you take from the work of another person, the better. If you take so much, then you have lost originality in your work and it is clear infringement. You can't be coming under the doctrine of fair use anymore. And lastly, the court will consider the market impact. So if having taken from the work of another person, you have hindered the market value of the original work, then you can't be coming under fair use anymore. And Raphael rightly referred us to the Gogo dance by Brain Jota and all that. In my own opinion, I don't think the dance by Brain Jota has affected the economic value of the original work of the power of the old man. To me, it even brought that song back to life. So some of us have never heard of that song before. We don't even know it existed until that time. So whoever has copyright in the work in that song must have, whoever has the royalties, the rights associated with the song would have made some cool money around the time the issue of the dance by Brain Jota trended. So Brain Jota can conveniently come on that phase. Of course, there are several arguments as it relates to that dance at that time. Another thing I will mention is emerging challenges with technology, AI content. So we now need to ask ourselves, who owns copyright in AI content? Questions about whether AI-generated works qualify for copyright protection remain unsolved. There are many arguments going on, but eventually we'll get to a point where we can safely say this is what would obtain. Because in most jurisdictions, it requires significant human involvement for a work to be copyrightable. So if we cannot link a larger percentage of human involvement to the work as of today, you can hardly get copyright for it. Another one is NFT, that's a non-fungible token. Owning an NFT linked to digital content does not equate to only the copyright. Disputes often arise when copyrighted materials is minted as NFTs without authorization. Also, recently, about either 2 or 3 years ago now, there was a man who was walking on the street, and then the guy took a picture of him and then made an NFT out of it. I think issues arose as who would own the copyright in the NFT. Again, these are discussions that are coming up in the recent digital age that we find ourselves. Nigeria, of course, we are waiting for the bigger boys in Europe, the white guys, to propound the theory so that we can take it further and domesticate it in ways that they can apply to us. We've heard this evening about how to protect copyright. I wouldn't dwell much on that again. There are trademark considerations in relation to digital content and comedy skits. And then so you observe that some of the skit makers that we have out there already have their logos. If you watch the skits of Brother Shaggy, you will see his red logo in one corner of his videos. If you watch even Sabinos, you see their trade name. If you watch Macaroni, you see their trade name. So each of these guys have their logos embedded in their work, and they can trademark those things because they are doing businesses with them. So one warning I must sound at this point is that you don't just wake up and register a trademark. You must be doing business with it. So you must be able to associate that mark with you. So don't just go and trademark a name, a logo, and keep it in the shelves. You must be using it from time to time. And that's one way to ensure that you keep it going. I'll be speaking on as regards DMCA, that is Digital Millennium Copyright Act of the US. This has to do with infringing works being taken down. And so most data creators share their work on platforms like YouTube, Instagram, TikTok, even Facebook. Personally, now I've taken some time to shoot videos as far as IP is concerned. In fact, I just finished a thread on trade secret in collaboration with a colleague of mine. We have 8 videos that summarizes everything about trade secret, and we back this up with an article that you can read in 12 minutes. So this work have been published on LinkedIn, on Instagram,
Hello, sir. I can't hear you. Am I the only one who can't hear me, sir?
All right. I don't know at what point you stopped hearing from me. I was talking about Digital Millennium Copyright Act. Can you hear me now?
Yes, sir, we can. It's just few
Can you hear
minutes.
me now?
Yes, sir, I can.
Can you hear me now?
Oh, wow. Yes, sir. Please go ahead. We can hear you.
Sophie, can you hear me?
Yes, sir. We can hear you now.
Okay, great. Thank you. So I'll just do this DMC and then I'm closing from there. So content creators publish their works on various platforms to educate, to entertain, and of course, indirectly, many of them are making money from this because they've monetized their work, their content, and all that. So, if you feel, you perceive, or you're certain that somebody has infringed on your work, you can report, you can bring your claims, or by virtue of the Digital Millennium Copyright Act. It allows you to report anyone who has infringed on your work, and then such works can be taken down. So as a digital content creator, in creating your own work, you must ensure that you don't infringe on the work of other person. Rafa was talking about bringing in somebody else's maybe music soundtrack to your podcast and all that. So these are the things that you can do that can hinder the normal flow of your work. Your work can be taken down. You can publish your work on YouTube and it goes down. Or you can publish your work on YouTube and the credit goes to the owner of a work you have infringed on. I know an artist in Nigeria that if you touch any of his sounds, you will not get a dime, no matter how many streams you get from that work. He will be the one to get everything. I know that Beyonce also has her work protected to the point that you can't even download it. You can't even afford to download it without paying through the right channels. So these are some of the things that happen. So the Digital Millennium Copyright Act addresses a number of these copyright issues created by the use of new technology and the internet, including digital rights management. It allows copyright owners to request removal of infringing content from online platforms. Yes, it enables copyright owners to issue takedown notices for infringing content. Creators can now file a counter notice if they believe their use qualifies as fair use, or if the takedown was issued in error. While this protects IP owners, it can be misused, leading to disputes over what constitutes infringement. The bottom line is that when you create your own digital content, ensure that you are original. Originality is the word. It saves all of us the headache of dragging ourselves up and down. Remember when Picnic did an advert with Sabino's something huge, that one trended at some point and all that. Then we later found out that Sabino's registered something huge under investments or something, not even entertainment now. So a number of these issues will come up and we'll start addressing them. For infringement, I will just refer you to Section 26 of the latest Copyright Act, that's 2022. It defines clearly what infringement of copyright is, and this is how it relates to digital content and that we're talking about this evening. In wrapping up, there are remedies for infringement of copyright damages, there is the injunction, there is a popular order, kind of profit, and there is criminal liability for infringement. So it goes beyond getting civil remedies for infringement. You can actually proceed to press criminal charges against a person. And that this also reminds us that the Copyright Commission has criminal powers to prosecute anybody found culpable of copyright infringement. The Copyright Commission has police powers to actually barge into premises suspected to have been used for counterfeiting and all of that. In conclusion, digital content creation is both a creative endeavor and a legal minefield. By understanding the legal landscape, copyright, privacy, trademark, and advertising laws, creators can protect their work, respect the rights of others, and avoid costly legal disputes. As digital work continues to evolve, staying informed and seeking legal advice when necessary will remain critical to thriving in this dynamic field. Now, by way of summing it up completely, as a content creator, as a digital artist, or whatever it is you do, never neglect the need for legal counsel, the need for legal advice. It goes a long way. Rafael mentioned using non-disclosure agreement with anybody you are disclosing your business your business with. At the talking stage, ensure you have them sign something such that in case that relationship does not work out, they are bound by the NDA they've signed with you. So protect yourself, prepare ahead. Don't wait till the yawa gas before you start looking for a lawyer. It's always good to have lawyers handy and on retainer. I'll keep it here so that we can take presentations from the mentees and then do the questions and answers afterwards. Thank you so much for having me. Thank you, Prof, for speaking earlier, and thank you, Rafael.
All right, thank you very much, Mr. Shea, for this session. Really appreciate you. Without further wasting time, would love to hear from our mentees. We'll be taking Group 1's presentation. Please, do we have Group 1 presenter on the call? Group 1 presenter, please unmute your mic and have your presentation, please. If Group 1 is not yet ready, please Group 2. Please unmute and please present. We don't have much time. The backup presenter or the presenter should please unmute, or whoever wants to take on the role of presenting, anyone from each of the group. Please unmute your mic, please.
Hi, good evening.
Good evening. Thank you.
I'm Miriam, and I'm the presenter for Group 2.
Okay, thank you very much.
So I'm going to start sharing my screen now.
All right.
Sorry, hold on. Sorry, please, can everybody see my screen?
Yes, you can.
Okay, so for Group 2, we are to take under comedy skits, digital content and content creation ethics. We are to take privacy and defamation, content creation ethics, digital security and piracy, emerging technologies, and international considerations. So I'm going to start with privacy and defamation. This simply entails that content creator must always, or content creators rather, must always navigate privacy and defamation risks while complying with media laws. Privacy and defamation risks can entail like privacy concerns, like revealing private or sensitive information about somebody or a group, recording or sharing content without the without the owner's consent, misleading portrayals, maybe like creating content about a particular person that is not actually true, saying, oh, this person did this or this person did that, or you could take the form of satire, which is not actually true, and that could harm the reputation of such person. They must also avoid defamation risks, such as making false statements that damage the reputation of somebody, slander, that's spoken words to damage somebody's reputation, and libel, which is always either written or recorded. Under content creation ethics, content creators must uphold ethical standards as their work influences individuals and society. Ethical content creation involves navigating cultural sensitivity, privacy, misinformation, and intellectual property rights while maintaining integrity. Sorry. So content creators must always follow a code of conduct. They should always ensure they follow certain ethical considerations. They consider certain ethics before they create content or they put their content out there for people to watch. Some key ethical considerations are cultural and social sensitivity. They should avoid harmful stereotypes or discriminatory humor, maybe making content that discriminates a particular tribe or a particular race or anything like that. They should always be sensitive to people's culture, races, whatever it may be. They should avoid anything like discrimination, misinformation, and fake news. They should clearly distinguish satire from facts and avoid deceptive content rather. When they are creating their content, when content creators are creating, if they have to state facts, they have to say what is true. If what they are creating is a form of satire, it also has to be a fact. It also has to be something that is actually true. Privacy and consent. Obtaining permission before featuring individuals in content. Before it might even take, it's not only like featuring individuals in content. Privacy and consent, like maybe before using somebody else's intellectual property, before using another person's song, before using anything that is not theirs, that is registered under another person's names. They should always seek consent before using them. Mental health awareness is more like being sensitive, as much as they also have to be sensitive to different people's culture and social groups. They should also be sensitive to people's mental health awareness. They should handle sensitive topics responsibly. Intellectual property rights, responsible monetization, digital security, and piracy. There are different ways for content creators to protect their digital content from piracy and unauthorized distribution. We have watermarking and branding, embedding visible or invisible watermarks to track content licensing agreements, takedown mechanisms, using copyright enforcement tools on platforms like YouTube, community monitoring. That means encouraging the audience to report anything that might infringe on their Copyright Act, and also regular content checks. There are different ways to implement digital rights management for content creation. We have access control, copy protection, subscription and paywalls, forensic watermarking. Access control, this is restricting access based on user credentials or location. They might restrict access. Some people might not be able to access this if they are not in certain locations, if they are not from certain places, or whatever credentials they may wish to say, for you to access this content, you must have these credentials. Copy protection, preventing unauthorized downloads or copying. Subscription and paywalls, ensuring only paying users access content. More like, to access this content, you have to subscribe to it. You have to pay a certain amount of money before you access their content. And forensic watermarking, Legal remedies for combating online piracy. We have copyright registration. When they register their copyrights, it always strengthens enforcement against infringement because their copyright is already registered. But they also have to make sure that the copyright they are registering has not been registered by somebody else. Cease and desist notices, warning infringers to remove unauthorized content, take down requests, litigation and damages. They might decide to pursue civil suits for financial compensation. There are different, like, there was a case between Femi Adebayo and a YouTube channel in 2024 where Femi Adebayo sued the YouTube channel for using for an unauthorized use of his movie poster and title, that suggests survivor of Jelili, sorry, to promote their own film on their platform. And this kind of like misled their fans and diverted revenue from Femi Adebayo to that YouTube channel. So it took them to court, he sued them for damages, and the court awarded him about 25 million naira for damages and litigation costs. So they can content creators, they can also decide to pursue civil suits for financial compensation, damages, and whatnot. Criminal prosecution, imposing fines and penalties for copyright violations. Public awareness, educating audiences on the effects of piracy. Emerging technologies. Technology is transforming content creation, but it also raises new legal challenges, from AI-generated skits to blockchain copyright protection and virtual reality comedy experiences. Legal systems must adapt to protect creators and audiences. We have AI-generated content now. It is like very common now, and also deepfakes. AI can create a content, but then maybe it mimics real people. When it mimics real people, and it's like maybe put them at risk against defamation, misinformation, and unauthorized use of someone's likeness. I actually saw something a few days ago where a doctor made a post, more like a disclaimer post, where it was warning people to actually against one, I think it was a drug company. They used his AI used his video, his likeness, they used his face and everything to promote their own drug and encourage people to buy their drugs. So he put out a video claiming it was not the one and it was just AI generated. And whenever people come across such videos, they should report it and also like send the link to him and all. Blockchain and copyright protection. Blockchain helps secure content ownership and automate royalty payments. It also prevents content theft by creating a permanent record of ownership, since blockchain is immutable, nobody can tamper with it. So there's always a permanent record of the owner of such content, which prevents content theft. Regulating comedy in virtual reality. Virtual reality raises concerns about copyright, privacy, and digital identity. Challenges include regulating virtual interactions and preventing misuse. There's also the question of, or maybe a virtual reality comedy, if it's or AI generated content, AI generated content, if it's like putting someone at, if it puts someone, sorry, at risk against defamation, who is responsible? Is it the AI or those that created it or those that used it? That is one of the legal considerations, legal issues under this technology. Lastly, we have international considerations. Creating comedy skits and digital content for an international audience requires awareness of cultural differences, legal protections, and platform-specific rules. Key considerations to note are cultural sensitivity and inclusivity. Content creators should always avoid content based on stereotypes, races, religion, or historical conflicts. They should research cultural norms and taboos before including them in their skits. Language and accessibility. Subtitles and translations would help reach a broader audience. When they create content, they can include subtitles and translations, so people that don't understand the language the content was created in can always see the subtitles and understand it. This would help them to reach a broader audience. They should use simple, universally understood expressions to enhance relatability. They should also consider voiceovers or multiple language versions for global engagement. Platform and regional regulations. Social media rules differ globally. Some countries also have strict censorship laws. They should Content creators should stay updated on regional content guidelines to avoid takedowns or legal issues. They should update themselves this with content guidelines in different regions to avoid takedowns or legal issues. Intellectual property and copyright protection. Copyright laws varies. Registering content in multiple jurisdictions in different places strengthens enforcement. Platforms offer takedown tools for unauthorized use. Some content creators can decide to register their copyrights, their intellectual property in different jurisdictions just to strengthen enforcement in such jurisdictions. Fair use policies differ. Content legal in one country may be infringing in another. Contracts and content ownership. When collaborating internationally, they should define IP ownership, revenue share, and jurisdiction in contracts. Licensing agreements should specify distribution rights and territory restrictions. In conclusion, digital content creation requires balancing creativity with ethical and legal responsibilities. Creators should navigate privacy concerns, defamation risks, and cultural sensitivities, religious sensitivities, while also ensuring compliance with copyright laws and intellectual properties. Emerging technology like AI, blockchain, and virtual reality introduce new opportunities and challenges, making it essential to stay informed and adaptable. Protecting intellectual property, respecting audience sensitivities, and maintaining ethical standards help build credibility and longevity in the industry. Ultimately, responsible content creation fosters trust, prevents legal disputes, and ensures a positive impact in the evolving digital landscape. That is the end of my presentation. Thank you very much.
Thank you very much for this for the effective presentation you made. I'm sure you put in a lot of effort and work into it. So really appreciate you and your effort. So if anyone has questions, please you can drop it on the chat box so that our mentors can review it while we are awaiting group one to present. So thank you so much, group two, for your presentation. Group one, it's over to you. Group one, are you available for the presentation? Is the backup presenter or the presenter, anyone in the group can unmute and speak, please? Oh, well, it seems group one can't present today or so. Um, Please, you can drop your questions so that we can go ahead with our mentors answering them. Thank you. So, does anyone have questions instead of just keeping mute? From the presentation of group one and from presentation of group two and of the all that the mentors have said today, does anyone have questions? Can anyone hear me?
Good evening.
Good evening.
Okay, my name is Chigozie.
Okay, nice meeting you, Chigozie.
Okay, my question is based on an incident that happened few years back between, I think it was Gala, was it, and Sabinus. You know, this is signature stance. So I don't know. Yeah, he uses it for part of his comedy and all that. I don't know whether I don't know whether that falls under trademark, because while the one of the mentors were speaking, one of the laws that was mentioned also guiding content creation will also be trademark when it comes to branding. Now, in that instance, and trademarks need to be registered. I didn't follow up the news, but I learned that Sabinus sued Gala for using his signature move and then saying that something huge is coming. So I want to understand, like, in this case, like, does it apply? Did did he, does it mean that, did he register the signature move as a trademark or something? That is what I'm confused about. I don't know how it applies in this case. That just making a move, that you can maintain an action as a result of that when somebody else uses it. That's my question.
Okay, thank you very much. Please, Mr. Samai or Mr. Shei, would any of you like to take on the to answer the question?
not really aware of the real facts. But if it's a pending case, I would not want to discuss it, but I don't know the facts of that case.
All right, let me
Okay.
chip in, Prof. So Sabinus has a trademark, something huge under class 30, one of the classes that has to do with investment. You know, he calls himself an investor in many of his key. So he registered something huge under for investment, for real estate and all that. Now it was Picnic who did an advert and introduced something huge into their advertisement. Then Sabinus threatened to sue them, wrote a letter, and probably went to court or something like that. So issues arose as, is there an infringement of copyright, I'm sorry, of trademark in this regard? And then when we analyze the basic issues confronting us, we realize that there's something huge that Picnic has done in this regard did not come under the class where Sabinus has his own trademark. And that is important. Now, if you do business in multiple
Hello,
areas
sir. I
that
can't
falls
hear you
under
again.
multiple classes, for
Or
example,
are you done speaking? Mr. Shea, I can't hear you. Okay, so Chigozie, I hope you were able to get a little understanding of your question. Because I think Mr. Shea was kicked out of the call due to, I think he's still on though, but I don't know. Probably it's network issues.
Okay, so I don't know why we're struggling with network when we should be having a good conversation. I've had it really nice all day. So sorry about that. Okay, so like I said,
Sorry
if your
about that,
business
sir.
cuts across
Can go
multiple
ahead.
classes, you need to register a trademark for that mark across the multiple.
So I think your network is too bad. But okay, so let's move to the next question. Probably when Mr. Shea is back, he will answer that for you, Chigozie. So Fina said, I see a lot of skit makers advertising some apps like trading apps, and by their adverts, followers get to use the app. I'm personally a victim of Octave FX and I lost so much. What laws regulate this activity of theirs, as I'm sure it's not part of their comedy making? Does the copyright law also cover this? So this is a question from Fina. I don't know, Mr. Andrews, Prof. Andrews, please, could you take that question?
Could you repeat the question again for me, or is it in the message?
Okay, so it's in chat box, but I can still read that out. It says, I see a lot of skit makers advertising some apps like trading apps, and by their adverts, followers get to use the apps. So she's personally a victim of Octave XX, and she lost so much. So what laws regulate these activities of theirs? As I'm sure it's not part of their comedy making. Does the copyright law also cover this?
Well, I think it was forgetting his name. The second speaker after the first speaker after me. I think he had done a good job on this area. So I dealt with the principles, the principal laws that governs creative works, especially on where we are now, the digital platforms and on the digital era. But you see, there are a lot of laws that govern creative work. What I'll call it tangentials or peripheral laws. So in this particular case, I mean, it's not from only in Nigeria, it's a global practice. I mean, people that in fact the presenter maybe unconsciously mentioned it in their presentation. You gotta monetize your creative work. That's the essence of copyright. I mean, intellectual property is to make money. When I say that, people, I mean, it's about making money, and on the back end, giving to society what the law requires you to give. So yeah, this area is actually controlled by another law. So you have, I don't know about Nigerian local laws, but I know that because, I practice in Nigeria for a minute. It's in the territory of consumer law. So there's a law in Nigeria. We have the Consumer Protection is it organization. There's a law that established the old institution, and there are framework on how consumers are, and in fact, it's a new law in Nigeria. It's protected. Now, there is issue. We also one of the presenters talked about thoughts. There's also the tortious aspect in this law. What am I saying? Is that injury, personal injury, if you lost money, if somebody has misrepresented his products, and you've lost, there's an injury to you, either your economic rights or health. So on that common law on torts, you can sue, you can go, seek redress. But again, specifically, and this issue of false advertising, that's another branch of law, which is also in Nigeria. We also had here, one of the speakers spoke about the guidelines on advertising. The basic law contract is that you don't sell BS, put it in a nice English. So if you come out and say, I'm going to sell this, there's an offer acceptance and all those things come together, and at the end of it, you didn't fulfill what you promised to do, see, I can sue. So there are a lot of rights for that person, but not strictly intellectual property. Because what are you going to talk about? Or what's your creativity? What's your creation? What's your invention that you've lost from? Rather, you have suffered injury from assuming that's the case, false advertising, false advertisement, somebody, in fact, there could even be criminal law aspect of it too. So yeah, so you talk to your lawyers, and there's a lot of remedy on those issues. Okay.
Thank you so much, sir. I'm grateful. Thank you, sir.
Thank you very much, sir, for that. I really do appreciate. So, please, do we have any other questions in the house? And also, I don't know, is there any member of group 1 that is on the call? So we can know. Okay, so I guess if we don't have any questions and we don't have group 1 on the call, I guess we've come to an end of today's session. So we thank everyone who played a role in today's session. We thank Mr. Prof. Andrews, Mr. Raphael, and Mr. Shei for their wonderful input into today's session. And I hope to all the mentees who are on the call, you were able to get and also learn few things or like a bunch of cool things from our mentors today. So really do appreciate everyone for joining in, and do have a wonderful night's rest. Thank you.
Thank you very much.
Yeah.